Oh, thank you, counsel. Ms. Blatt?
Mr. Chief Justice, and may it please the court. The petition asks whether Rule 60C1 imposes any time limit to set aside a void default judgment. The answer is yes. The plain text requires that B4 motions be filed within a reasonable time. The phrase reasonable time does not mean any time. First, any time would include an unreasonable time, the exact opposite of reasonable. Second, by definition, reasonable means within just limits, not whenever. Third, a reasonable time means courts actually consider the facts of an individual case. It doesn't mean the move-it wins regardless of the facts. Fourth, had the drafters intended no time limit based on the grounds for relief, they easily could have placed void judgments under 60D, which has no time limits. Notably, D3 allows relief from judgments at any time for fraud on the court. The three courts below ruled petitioner's delay was unreasonable. The Court of Appeals stated, quote, Coney Island has not argued that it brought its motion within a reasonable time. The district court said the delay is unreasonable and Coney Island offers nothing to justify the delay. And this from the bankruptcy court, Coney Island has not even contended that the delay should be considered reasonable. I welcome questions.
Is there a way to challenge a void judgment beyond Rule 60?
Well, we don't think so based on the text of the rule and the history. The rule itself is pretty expansive. It says it is the way to get relief from a valid judgment, and the history is pretty clear. The advisory committee notes, which are codified, says it's obvious that this is the only way to get relief. We're trying to, close the door. The text of Rule 60E abolishes all the common law writs and remedies that were used to get relief. And we would rely, for those who care about this kind of stuff, the advisory committee chairman said there's no way left to get relief other than Rule 60. I mean, you don't have to decide that, and 60D has the one independent action, so they did leave that safety valve. That was very important to the drafters, that there's always an independent action. This court in United States versus Beggarly has said Rule 60D independent actions are reserved to correct gross miscarriages of injustice. So there is that Supreme Court case that says that. And the rule committee note says that laches applies to those kind of